25 minutes past 7. It's time now to link to our TNA. It's happening in Rosebank this morning, and our guest of honor is Minister Nelisiwe Mildred Oliphant, who is in charge of the Labour Department. We've also got Thobile Lamati, the Director General of the department, and Nerine Kahn, the National Director of the Commission for Conciliation and Arbitration. They're going to be discussing the labour law amendments and what they mean for the labour market. Well, Peter Ndora is the man who's going to be heading up this conversation, so I throw over to him. Peter, good morning, and we look forward to your conversation.
Right, Leanne, thank you very much indeed. Yeah, we're in Rosebank today, which is just north of central Johannesburg, and this is the venue, as I said, for the latest in the series of New Age business briefings brought to you by the SABC and today sponsored by Transnet. And sharply in focus today is the amendments to the Labour Relations Act. And for those of you who perhaps haven't been paying attention or didn't know, the bulk of those amendments came into being in January this year. So they're law, and they're in play. So we should all be abiding by them by now, both employers and employees. We've all got responsibilities to abide by those amendments as they are law. And the job of this conversation today really is to unpack what those amendments are, what they mean, and how that has changed the labour law landscape and the workplace, I guess, in many facets. And to help us unpack some of those issues, I'm very pleased to welcome our panel, and starting with the Minister of Labour, Honourable Nelisiwe Mildred Oliphant. Thank you very much for joining us, and welcome. It's great to have you once again. It's been a while. Thank you and welcome.
Thank you very much, Peter, and thank you very much to the audience for their attendance today. And also, I just want to say good morning to the listeners.
Okay, and joining you is Director General, Department of Labour, Mr. Thobile Lamati. Thank you for joining us. I know that you've become DG in the last few months as well, so new in your job, and rolling out this, I guess, a big communication plan, capacitating this. We'll be looking forward to hearing what you've been doing in that respect, and welcome to you.
Good morning and welcome. Thank you for having us here, Peter. I consider this as a baptismal of fire, but it is I welcome it. I appreciate it. Thanks.
Great. And perhaps a face that might be familiar to you as well, Ms. Nerine Kahn, National Director, Commission for Conciliation and Arbitration. That's the last time I'm going to say the full name. After that, we'll just call you the CCMA. Thank you so much. Thank you so much.
Thank you very much, Peter. Thank you for having us. And it is interesting that if you say to people the Commission for Conciliation, Mediation and Arbitration, they don't know what you're talking about. But if you say the CCMA, they know immediately.
All right, okay, so let's start unpacking this, because it is a watershed moment, I guess, in terms of the landscape for labour law, labour relations in many respects. So, Minister, let me start with you. Let's go back a little bit as to why the need for the change in legislation or the amendments to the legislation, and what journey took you to where we are in terms of these amendments now becoming law.
Thanks very much, Peter. As are we all aware that we are a constitutional country, and the legislation that we have in this country emanates from our own constitution, particularly under the Bill of Rights. And by the way, the constitution also, most of the clauses emanates from the Freedom Charter. And as we are celebrating 60 years of the Freedom Charter this year, I think it's an honor and pleasure for us to come and discuss with the labor issues. What I have to tell you, Peter, is that we looked at the challenges that the country is facing, particularly on the issue of casualization. And that's when we had discussions on the ILO, of which all the constituencies, NETLEC in particular, participate in those forums. I must say I'm very happy because even in those forums, government, business, organized labor, and even communities are participating. And therefore, our legislation emanates from also the resolutions that are taken in the International Labour Organization, of which all that I have mentioned, the constituencies, are also part and parcel of being signatories. And in particular, these amendments started in 2010. I was not the minister by then, at the early year of 2010. So what has happened is that we have looked at those issues, and we also did the regulatory impact assessment on what will the impact of the amendments. And we're looking at how we have to deal with the exploitation of workers in particular through the labor broking system. And what we have come up after the discussions at NEDLAC, we all agree that whenever we employ workers, they must be employed in terms of the labor relations, basic conditions of employment, and also employment equity. And I must say also, we came up with the new legislation, that is the Public Services Act, that deals with the regulating of private agencies, including the temporal employment agencies. And therefore, the laws that we're talking about today give the workers a situation where we are saying, because looking at the issue of casualization, you'll find that in South Africa you have people who have been employed for more than 10 years as casual workers. And you can't continue having the casual worker as a casual worker, because that person, in fact, in terms of the social protection, is not covered. And therefore, that's the reason why we have taken a decision to amend those legislation. And also, when it comes to the temporal or contract workers, the challenge was that they will be doing the same job with the permanent workers, but they were not getting the same salary. That is why, in terms of the employment equity, we have said there must be equal pay for equal work of the same value. So those are the things that we have decided to do. But I must say also, when we're looking at the issue of the basic conditions, we said, one, in terms of the employment as well, there are bargaining agreements, and therefore workers as well must be employed in terms of those bargaining agreements, including the sectoral determinations. So I believe that since we have all of us agreed and participated in these amendments, we'll be able to implement and comply with all those laws.
All right, so it's been quite a journey, and I get a sense that you were careful to make sure that everybody was included in the input that informed the legislation in the end, and so that the documents and the amendments are a reflection of what people were concerned about on both sides of the equation.
Yes, business was part of that, organized labor was part of that, government was part of that, and also the community. Community includes the non-governmental organizations. And that process started at NEDLAC, of which there was a consensus on those amendments. And then we went back to Cabinet to say these are the proposals from the NEDLAC, and then the Cabinet take a decision to continue with those amendments, and then we have submitted the legislation in Parliament. And Parliament as well have taken its process, and also there were opportunities for the very same constituencies to go and table amendments or propose amendments if they wished. And in fact, I must say, as the government initially on the issue of contract work, we proposed 6 months, but when the legislation was finalized by Parliament, they ended up proposing 3 months. So those processes, everybody, including the community in general, they had the opportunity to go and make their proposals on those amendments. Right. So I must say everybody really has participated in the process. Okay,
so in theory there should be no dissenting voices, but I have got a feeling we may hear those voices. DG, so the journey has taken us here, and I guess what I need to know is how we're going to get to roll this out, capacitate people on both sides of the equation, because employees have responsibilities, employers have responsibilities, and what effect is it going to have? I mean, is this a watershed moment? Is this a game changer?
Yes, it is, Peter. I just want to preface my response to your question by indicating what our vision is as a Department of Labor. We want to create a labor market where there's investment, there's economic growth, there's job creation, and also there's decent work. So in the process of developing these regulations and these labor market policies, we were not oblivious to the fact that business has to continue and business has to do business in a manner that they are not, in an unhindered manner. So we then said as a Department of Labor that part of what we have to do is to take people through the legislations, get them to know what the legislations mean and how they can benefit from these legislations. So what we've done thus far is we have had roadshows together with the CCMA, where we were taking people through the different aspects of the legislations. Now, what is important, Peter, is that as a country, as the Minister has mentioned, we are a rights-based kind of an economy. And these legislations have, by and large, provided those workers that were sort of in the cold, provided them with legal coverage. And also what we've done is we've simplified the enforcement processes, because in the past, what workers and employers have been saying is that part of the problem that we have with regards to the labor brokers, for instance, was that the Department of Labor was unable to enforce these legislations. And our argument has always been that the enforcement processes that we have were not enabling the inspectors to do their work properly. And what we've done with the amendments, we've simplified the process such a way that an inspector can just go and do an inspection and write a compliance order and then refer that compliance order to the labor court if the employer has not complied with that compliance order. In the past, an inspector had to endeavor to get the employer to undertake that I will comply with the law. And the employer would then not honor the undertaking. And after that, the inspector has to then write a compliance order. And the employer would then object to the compliance order. So it was an elaborate process. So what we've done now, we've simplified it. But also most importantly is that business often say they thrive in an environment where there's policy certainty. What we've done with these amendments is we've provided that policy certainty. We've removed all the areas that were ambiguous in the past. Okay. We've simplified them. Yes. All right.
Okay. And I look forward to unpacking a lot of that. But very briefly, just before we get into the break, and we'll unpack a lot more of what you're going to say. But just by way of introduction, the CCMA is affected by these amendments and gives you a bit more teeth to deal with some issues. So this is a watershed moment for you too.
Certainly it is, Peter, thank you. I would say that the CCMA doesn't have inspectors, those fall under the Department of Labour, but in relation to everything else, it's sort of the doing arm of the amendments, and the role the CCMA has is to implement those amendments and make sure that the laws that they deal with actually are applied, and people can bring their cases to the CCMA, they can conciliate or arbitrate them, or deal with other issues that might arise out of that. That's a summary in relation to that. So the CCMA's role is to take the policy and to actually bring it into life in relation to that. We have, as the DG has mentioned, been on extensive roadshows around the country, and we're also going to be having a large communication campaign that's going to roll out over practically the whole of the rest of the year, because it's important that everybody understands their roles, their rights, and their obligations in relation to this, but also that you can actually bring your case to the CCMA and under what circumstances you can. I mean, it's important to note that many of the amendments fall particularly in focus on the more vulnerable of the workers in our society who earn below the threshold of what we talk about, which is 205,433 rand and some change.
Right.
So that's a significant thing.
Okay, I'm going to pause for thought because I'm going to take a quick break. But when we come back, I want to really start unpacking some of the issues that we've raised here, and I want to know the powers that you have now, because I know that you've certainly got some powers that they're going to be able to speed up processes and empower workers a little bit more, and I suppose help employers as well to get things resolved much quicker. So all of that's still to come, and we also look forward to your questions at Morning Live, SABC, as well on Twitter. So stay with us for more after this.